Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This podcast will be about 10 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself. And finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Solda versus KJL Ventures, LLC, a fairly recent New York City Civil Court, New York County case about how a tenant recovered a $9,000 security deposit from a landlord who did not want to give it back. First, let's set the stage with some context. For non-rent stabilized tenants, residential security deposits are regulated by New York State General Obligations Law 7108. Don't worry, rent-stabilized tenants have even more rights than what we're looking at here today, and I'm sure we will cover that in the future. But so far, we've given a lot of attention to rent-stabilized tenants on the Tenant Law Podcast, and today we're giving some love to the non-rent stabilized tenants. There are many protections in General Obligations Law 7108, but here is a new one since the Housing Stability and Tenant Protection Act of 2019 that not a lot of people seem to know about, and it is very good for tenants. According to General Obligations Law 71081AD, within a reasonable time after notification by either the landlord or the tenant of either's intention to terminate the tenancy, unless it's the tenant terminating the tenancy with less than 2 weeks' notice, the landlord shall notify the tenant in writing of the tenant's right to request an inspection before vacating the premises and of the tenant's right to be present at that inspection. If the tenant requests such an inspection, the inspection shall be made no earlier than 2 weeks and no later than 1 week before the end of the tenancy. And then the landlord shall provide at least 48 hours written notice of the date and time of that inspection. After the inspection, the landlord shall provide the tenant with an itemized statement specifying repairs or cleaning that are proposed to be the basis of any deductions from the tenant's deposit if they don't get done. And this way, the tenant has the opportunity to cure any such condition before the end of the tenancy. So that's the context you need to understand what's going on. Now let's get to today's case. Now let's get into today's case. On October 15th, 2022, a representative of the landlord sent an email to the tenant saying they acknowledged the tenant had already told them that he was leaving on November 15th, 2022. So that's more than 2 weeks' notice. That's a month's notice. Tenant asked about an inspection. Landlord said it would inspect after tenant moved out. Tenant moved out. Landlord contends that tenant left things in the apartment that should not have been left and refused to give the tenant the $9,000 in security back. Now, as we saw in the first segment, according to the General Obligations Law, when a tenant gives a reasonable and more than 2 weeks notice that it is terminating the tenancy, then that triggers an obligation by the landlord to notify the tenant of their right to request an inspection. Here, landlord did not notify tenant of its right to request an inspection in accordance with the statute. In fact, landlord did the opposite. Landlord informed the tenant that landlord would be inspecting only after tenant left. So for the court, this was the end of it. The statute was not complied with, so the court ordered the landlord to give all the security back no matter what condition the apartment was left in. Thus, we have a very interesting tenant takeaway. But first, let's get the housekeeping out of the way. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this may be considered legal advertising. If it is legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions. I might be answering listener questions on the pod, but not announcing your name. I'd love to say what New York City neighborhood you're from. If you like our work, please give us the 5 stars. And put this on your socials because you might not need this information today, but someone else might. Okay, it's time for the tenant takeaway. So today's tenant takeaway is if you're not a rent stabilized tenant and you are leaving your apartment, let the landlord know more than 2 weeks before the end of your tenancy that you intend to leave. And do that in writing, like with a certified letter or an email, something that's going to keep a record. At that point, wait to see if landlord notifies you of your right to request an inspection. If landlord says nothing about your right to an inspection, maybe you should not say anything either. Because according to this case, at least, which is just a lower court case, but it seems to be tracking the statute pretty accurately, no matter what the condition of your apartment is in, you're going to get your security back just by virtue of the fact that the landlord did not notify you of the right to request an inspection. I checked right before publishing this episode, and I don't see any evidence that this matter is being appealed, but keep your eyes open for more information on this topic, and be sure, as always, to speak to your own lawyer in these situations. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law, so let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.